This panel deals with an issue from what I call the other side of the looking glass, the failure to address some of the unethical and illegal conduct of members of the legal profession. It goes without saying that the vast majority of lawyers, whether on the plaintiff or defense sides, are honest and ethical people. But too often we've seen severe misconduct by some members of the plaintiff's bar. Earlier this year, a federal judge in New York ruled that a plaintiff's lawyer committed massive fraud in the long-running Chevron Ecuador case, including bribing judges and fabricating expert testimony. Another federal judge in North Carolina recently found evidence of systemic misconduct by plaintiffs' lawyers in asbestos cases. Our panel will discuss these and other examples of abuse, and it will discuss how courts, the ABA, and state bar associations can act to prevent misconduct by lawyers. To moderate the panel, we have Paul Barrett, Assistant Managing Editor and Senior Writer at Bloomberg Businessweek. Since joining the magazine in 2005, he's written cover stories on subjects as varied as the gun industry, oil trading in the Republic of Georgia, and the world's largest chain of funeral homes. He's a graduate of Harvard Law School and previously spent nearly 2 decades as a legal affairs reporter at the Wall Street Journal, and he is the author of 4 books, including his most recent book, Law of the Jungle, which is about the Chevron Ecuador litigation. It was described in one review as an enthralling real-life courtroom drama. Law of the Jungle went on sale just last month, and following this panel, you'll have an opportunity to meet Paul next door in the briefing center if you'd like. In addition, some of you have been randomly selected to receive a free copy of the book. If you look inside the back cover of your program, see if you have a free book sticker, and you can claim your book at the registration desk where you first came in. So with that, I'm going to turn it over to Paul and his very capable hands. Thank you.
The buzz over the free book. Got to remind them, though, that some people have to buy the book. Good morning. I'm very pleased to be here. Thank you for that introduction, Lisa. Very kind of you. I want to drop one quick footnote at the outset, which is I'm here in my capacity as a journalist and an author. I am not part of the Chamber's initiatives on this or other subjects, although, of course, I'm interested in them from the point of view of reporting on them and analyzing them. This morning we have an extraordinary panel of attorneys and public officials to talk about problems with mass litigation and attorney misconduct. I'll start with Melissa Brown of Georgia Pacific, who is the Chief Legal Counsel for Legislative Legal Affairs at that company. She's responsible for the company's civil justice reform initiatives, including those related to class action litigation. Before joining Georgia Pacific in 2007, Melissa was a partner at Bach, Robinson & Lewis here in Washington, and earlier a lawyer at Aiken Gump. Melissa also spent 4 years in Uganda working with USAID and other organizations. Thurbert Baker is a partner with McKenna, Long & Aldridge, where he focuses on corporate compliance, state legal and legislative matters, and on that latter topic is uniquely qualified because he served earlier for 13 years as the Attorney General of the state of Georgia under 3 different governors, which has to show an extraordinary amount of political deftness. In 2009, he was the recipient of the first annual Barack Obama Political Leadership Award from the National Bar Association. And he began his career in politics in the Georgia House of Representatives, where he served for 8 years. Sitting next to me is Neil McBride, a partner with Davis Polk and Wardwell here in Washington, where he focuses on, among other things, government enforcement actions and complex litigation. His background is equally appropriate because before that he was the U.S. Attorney for the Eastern District of Virginia, where he prosecuted cases on an extraordinary range of subjects: financial and securities fraud, international corruption, military procurement fraud, and terrorism. He had earlier served as the Associate Deputy Attorney General at the Department of Justice. From 2005 to 2008, he was the Vice President and General Counsel of the Business Software Alliance. And earlier, he served as the Chief Counsel and Staff Director to then Senator Joe Biden on the Senate Judiciary Committee. So an extraordinary array of credentials. I'll start by elaborating somewhat on what Lisa said about the Chevron case, which is the subject of my book and probably my only claim to expertise on this otherwise this panel that I'm badly outmatched on. In February of 2011, a court in the rainforest of Ecuador in a town called Lago Agrio, which means sour lake, a town that had been named by petroleum engineers for Texaco in the late 60s when it was an oil camp, and they named it after the town in South Texas where the Texas Oil Company had been founded at the turn of the 20th century. This courthouse in Lago Agrio was the site of a judgment against Chevron for $19 billion, holding the company culpable for pollution in the surrounding area that took place in the 70s and 80s. The responsible company was said to be Texaco, which Chevron acquired in 2001. The American lawyer who brought this lawsuit and won this victory had brought one and only one civil lawsuit in his entire career since graduating from Harvard Law School, this one. First time out, $19 billion verdict. His name was Stephen Donziger, and he was celebrated in environmental and liberal political circles worldwide as a hero of the environmental movement. As Lisa said, some 3 years later, after Chevron had sued Donziger under the U.S. racketeering law, a federal judge in New York ruled that this $19 billion verdict was a complete sham, that it had been obtained with fabricated evidence by means of the coercion of Ecuadorian judges, and ultimately, as the federal judge in New York found, the ghostwriting of the underlying judgment related to those $19 billion in damages in exchange for a promise to pay the Ecuadorian judge $500,000. At present, we have a collision between the American judiciary, which says the Ecuadorian case is a fraud, and the Ecuadorian judiciary, which has upheld the Ecuadorian verdict. The plaintiffs are seeking to enforce the Ecuadorian verdict in courts in Canada, Argentina, Brazil. Chevron is seeking to basically give meaning to its RICO finding that Donziger may once have been a plaintiff's lawyer, but evolved into an extortion artist, a racketeer. The record in this case, as a factual matter, strongly supports Chevron's version of what transpired in Ecuador. There was misconduct, in my judgment, on a massive scale. Of course, my judgment doesn't matter so much. It's Judge Kaplan's opinion in New York that's important. Today, we're going to talk about several topics that you can see as stemming from the Chevron case. One topic is the potential use of the civil racketeering statute by corporate defendants as a weapon in fighting back against mass litigation that the companies see as illegitimate. A second question is where this kind of misconduct may be taking place in other industries, such as the industries that have been exposed to asbestos liability. And third, there's the interesting question of why state and bar association authorities have not been more aggressive in self-regulating the legal profession. I think we should start with Melissa Brown, who is going to talk a little bit about recent developments in, what are we now in, the fourth decade of asbestos litigation. And there's a fascinating case involving a relatively small gasket manufacturer called Garlock that could open a new window on the degree of misconduct in this late-stage asbestos litigation. And I think Melissa's going to tell us a bit about that.
The Garlock findings from Judge Hodges in January of this year certainly are deserving of a media spotlight and a lot of attention. To quote the judge, The last 10 years of this defendant's participation in the tort system was infected by the manipulation of exposure evidence by plaintiffs and their lawyers. 10 years. He went on to find that exposure evidence, quote unquote, disappeared, that the plaintiff's lawyers regularly withheld evidence, engaged in quote unquote demonstrable misrepresentations, and quote unquote extensive abuse. So this is certainly a case that deserves the media attention it's getting. What I'd like to do is back up just a little bit and talk about what asbestos judges around the country have been seeing for the last 10, 15 years. And to do this, I'm just going to use their own words and talk a little bit, not at length, about the cases they were addressing, and contrast it to the Garlock case, which I think there are equal levels of abuse. And at the end of the presentation, just pose the question why there have been no sanctioning mechanisms applied to any of the attorneys involved in any of the cases that I'm about to talk about. This case was a couple of years ago. Judge Abelman, who ran the asbestos docket in Delaware at the time, is obviously greatly incensed at the attorneys in front of her. In this case, 20 trust claim forms that described exposure to 20 different products were not turned over through the 2.5-year course of litigation until the Saturday evening before a Monday trial start. The plaintiff's counsel sent an email to the defense counsel and said, oops, I have 20 claim forms. Judge Abelman spent a considerable amount of time addressing this. It then moved on to a second judge who also addressed it at length. But this would fall into the category of miscommunication between attorneys as the excuse. There were 4 separate plaintiffs' firms involved, and none of the 4 received any kind of sanction. But you would think with language like this coming from a judge that this would never occur again in Delaware. Everybody's been put on notice that the Delaware judges are paying attention to this issue, that it's important to the maintenance of the justice system that basic discovery requirements be addressed. Nope, sorry. September of this year, another judge, a different plaintiff's law firm, basically the same factual pattern. Trust claims were filed, never turned over, eve of trial rolls around. Oops, here we are. And again, this is the miscommunication between multiple law firms scenario. I would not have wanted to have been in the plaintiff's lawyer's shoes saying to the judge, well, yes, Your Honor, mistakes were made, but. And again, we're talking about something systemic, something that the court obviously thought it had addressed in its individual court system a long time ago, 3 years before this case, and obviously had not addressed it deeply enough. The additional excuse in this case had to do with the fact that the trust claims that were submitted were basically submitted blank with a name of a plaintiff and some information, but as the plaintiff's counsel said to the court, well, they weren't done yet, so we didn't have to turn them over. Interesting. So that falls into the they weren't done yet excuse. Different state, different asbestos docket, same problem. Again, we're in a situation where trust claims were not turned over until the eve of trial, in this case, 3 business days before the start of trial. And we're talking about 10 different trust claims that, again, show exposures totally different to the exposures described in the litigation as it proceeded. Again, the excuse seems to be, well, a little miscommunication, but in this case, the trust claims don't actually need to be based on anything, so they aren't actually proof of any kind of exposure, so they're not actually facts, so we don't have to turn them over. I think the judge's quote at the bottom says it all, and this particular judge went on and addressed this at length with the attorneys in front of him, and again, talked to them about, don't you have to have a substantial basis in fact for filing a trust claim and making a factual claim? So, obvious frustration on this judge's part. Again, you would think, having addressed it at length in a particular case, that the issue would be done in Maryland. This judge took the additional step of holding an all-docket, all-claims hearing that went on for almost 5 hours to set forth his expectations regarding trust claims and exposure facts and what gets turned over. And you can see the colloquy in front of you on the screen. So you're telling me you can file a bankruptcy claim and collect money even though you have no reason to believe you were exposed to asbestos. 2 different plaintiffs' attorneys from 2 different firms confirmed, yes, that's absolutely right. The judge running the asbestos docket disagreed with them and put additional discovery requirements in place. So again, are we done? We should be done in Maryland. Well, the experience of a defendant in 2013 having to file motions for sanctions after verdict when they found out about additional trust claims that had never been turned over would say, no, we're not done in Maryland. Let's move along. New Jersey. Again, hiding basic exposure facts. Discovery rules totally ignored, discovery rules totally flouted. The defendant himself is found by the court to have intentionally lied to the court about his exposures. He lied in every form of discovery he could possibly lie in. And obviously, his attorneys were involved in presenting his testimony all the way along, through discovery, through deposition. So, are we done in New Jersey? No, we're not done in New Jersey. This is now a year later. Similarly, trust claims not turned over. Again, miscommunication. In this instance, actually a very firm statement by the plaintiff's attorney involved that it wasn't his responsibility to figure out what another firm was doing. That it was another firm and he can't be obliged to follow what goes on in another firm, even though it's in his case. This is, again, a variation of the separate counsel did it, so I don't have actual knowledge of it, so I'm not responsible for it. Moving along, Texas. In this case, the judge actually, as you see at the bottom, points out the Code of Professional Conduct to the plaintiff's attorneys in front of him. Their excuse for not turning over basic discovery information is it can't be attributed to the plaintiff because we filled it out and he never saw it. So, new twist, right? We've had I didn't communicate with my co-counsel. We've had the claims weren't done yet, so we don't have to turn them over. We've had they're not based on facts, so we don't have to turn them over. And here we have the lawyers did it, so they're not actual facts that can be attributed to the plaintiff excuse. Virginia, this is one of my favorites. Mainly because in the very lengthy transcript that came out of this case, the basic excuse was my client is dumb and didn't tell me anything. So now instead of blaming it on other lawyers, they're actually going to blame it on the client themselves. The reason they had to punt and go blame the client is because the material that was not turned over, including the additional lawsuit in New York City. So we're not talking just trust claims material, which as you can see is subject to vagueness, one would suppose, but an additional lawsuit and material based on that additional lawsuit. And they had to punt to the plaintiff because it wasn't separate counsel, it was their own law firm. Different office, different lawsuit, different state, but it's a little harder to say I can't be accountable for something that is going on in my own law firm. So they punted to the client. In all of these, were there sanctions against the attorneys? You can see that in one case, the most recent case in Delaware, in September of this year, there was a $1,000 fine allegedly for the cost of the motion to compel that the defendants had to bring. Now, any of you who are lawyers or who have retained lawyers know very well that $1,000 is not the cost of a motion to compel and the hearing that accompanies it. In all the other cases, although some of the conduct was so egregious on the plaintiff's part that the cases were dismissed, there were never sanctions against the lawyers, ever. What tends to happen is that when something like these examples is brought to light, obviously there's a drive to settle the case. And if the defendants are no longer in the courtroom pushing the judge to do something, nothing happens. But from a corporate perspective, I think the question becomes, in this age of over-enforcement against a corporate defendant, as Lisa described, if it was a corporate defendant standing in the well of the courtroom saying, there may have been facts that we knew, we thought we knew, then we realized we didn't know it. If any of your counsel stood in the well of the courtroom and said that to a judge, the assumption would be enforcement of some kind against them, enforcement of some kind against you as the corporate defendant. So, I know we went through this pretty quickly, but where I'd like to leave you with is sort of the plaintiff cry from the head of the Maryland asbestos docket, which is, so everybody just lies and nobody cares. Thank you.
As a transition, Mr. Baker, maybe you could offer a thought as to why the judges that Ms. Brown is quoting didn't take action based on their observation of the manipulation they saw, and then move on to your main topic, which is why we do not see aggressive action, generally speaking, from the bar associations or state attorneys general.
Thank you so much, Paul, and thank you for that wonderful presentation. It's a great way to segue. I'm not going to talk bad about judges too much this morning. We all have to go back and visit with judges from time to time. But I will say this.
About the politicians.
And I will say this. I mean, judges are lawyers, and judges tend to act in the same way as lawyers act, especially when it comes to this profession and how lawyers engage and how we conduct ourselves in court, especially when we're talking about mass litigation cases. So I think, as you will see in my discussion, part of the problem we have can be found really and rest with judges around the country who are not aggressive enough in monitoring lawyer conduct and making sure that sanctions are appropriate. But the question, Paul, that you raise is a very complex question that I think the ABA and state bars around the country have for decades grappled with and tried to find reasonable solutions. You may know, and I think you mentioned, for 13 years I served as the Attorney General of my state, and what I also did during that time was to serve as the liaison between the National Association of Attorneys Generals and the American Bar Association House of Delegates, which is the governing body for the ABA. And so I had an opportunity to see up close, working with other lawyers and judges from around the country, how this issue was dealt with. And I will tell you, it is one of the more perplexing issues out there. First thing I will say, though, in all fairness to the ABA is, and some of you will know this, the ABA is a voluntary organization. It does not have the powers to sanction lawyers. It does not have the power to bring those kind of actions against lawyers who may have been on the wrong side of ethical conduct. The power that the American Bar Association does have, however, Paul, is the ability to promulgate rules and policies, to sort of outline the conduct for lawyers as we engage in mass litigation cases and how we might conduct ourselves in that process. They've done a pretty good job of promulgating rules and regs. 49 states around the country have adopted the model rules from the American Bar Association, so that's a good positive thing. In particular, to answer your question, what the American Bar Association has done is that years ago they promulgated a rule 8.3a, which really talks about what we ought to do as lawyers, as a body that governs ourselves, what we ought to do when we see misbehavior in these cases, especially in mass litigation cases. And many of you will be familiar with 8.3, but basically 8.3 says that any lawyer who is aware of or sees conduct that we believe violates the rules of professional conduct such that it reflects poorly on that lawyer's honesty and trustworthiness, ability to be a lawyer, that if we see it as lawyers, Paul, we ought to report it. That's basically what 8.3 requires. Now, the interesting thing about 8.3, many of you will know, is that it does not require a lawyer to self-report. So if I see you doing it, I can report you. If I do it myself, I don't have to report it. That's a problem. There are some states, I believe, who do require self-reporting. California, in particular, is a state that requires it. If there is a sanction imposed on a lawyer of $1,000 or more for misbehavior, fraud, or misrepresentation. So some states will require it, but the ABA bar rule does not. So why do we have this lack of oversight? Not just from judges, but I think from the bar community in general. So in preparation, I wanted to make sure I had my facts right. So I canvassed a number of state regulators around the country. I talked to bar members, and I talked to some lawyers, and I talked to a number of attorneys generals as well. Let me share with you some of what I found out. So there were a number of reasons given to me, at least, why we don't see as much oversight as we should here. The first one that I heard most and foremost was that we as regulators are not always aware that there has been a sanction filed against an attorney or that they've been engaged in some level of misconduct. And I was shocked to hear one regulator tell me, you know, Thurman, I'm not even aware of this Chevron case or the Garlock case, and obviously this regulator was not from New York or North Carolina, but you know, the point that this regulator was making was, don't assume that we all know that these actions have been taken against lawyers. The second point that I heard a lot was that regulators tend to be reluctant to get involved in ongoing litigation. They see that sometimes as matters that might impact negatively on the litigation that's in process, so there's a general reluctance out there to get engaged. They think if they got engaged, in many instances, it might hurt the client who's actually involved and has a stake in the outcome. I'm also told that they see this process of filing disciplinary actions against one lawyer as a litigation tactic from one side against the other. And so they don't want to get involved and to assist someone who's engaged in that kind of practice. More often than not, I heard this excuse, and I term it an excuse, but it was their rationale from regulators. We expect the judges in the case of mass litigation will handle any sanctions, Paul, that there might need to be meted out. That I found to be interesting because as a follow-up, they say if we believe the judge is going to handle the sanction, we don't see it as our responsibility as a state bar or as a regulator to actually get involved and go behind the decisions of that sitting trial judge. Conversely, they say, if a trial judge has looked at the problem and chose not to engage in his sanctions, we don't dig deeper into that judge's decision. Now, I will tell you all here this morning, it's clear to me at least that there is a substantial amount of misbehavior in mass litigation and other cases that goes unreported. And I think we all grappling for the reasons why that happens. I think there is a general reluctance, quite frankly, among and between members of the bar who are in the best position to see the misbehavior. There's a general reluctance to report it. And I think, quite frankly, that's a mistake because that in and of itself undercuts and undermines the integrity of our legal profession. It compromises our disciplinary process, and those are issues that we all have to be concerned about. I think, quite frankly, that we're going to need to find more mandatory ways to report misbehavior in mass litigation out there. Some thoughts for you to consider this morning. Court reporters are in the middle of all of these cases. They are recording. They know when sanctions have been imposed. Can we think about some way to require mandatory reporting through court reporters who are sitting at the table in all of these cases? Malpractice insurance carriers are sometimes required to report sanctions in these cases, and I think if that happens, that we ought to at least give some thought to malpractice insurance carriers being required to report misbehavior in these cases. You know, there was a case several years ago that Daimler Chrysler was involved in. Some of you might remember it, but the defense lawyers actually brought a separate lawsuit against the plaintiff's lawyers in Texas, accusing them of falsifying evidence. They brought a punitive damages lawsuit, Paul, and I think, in my opinion at least, that's an emerging tactic that we all ought to think about, because it allows us to really shift the focus of what's going on in these cases. And if those lawyers on the other side are engaged in misbehavior, malpractice, fraud, we ought to be able to expose that in some way. And then finally, I think we've got to revisit Rule 8.3. It is a rule now that requires us as lawyers to report misconduct when we see it with other lawyers. But I think we ought to look at the question of whether or not we ought to have require mandatory self-reporting, Paul, such that now we will get a fuller scope of view of what's going on out there, and hopefully, level this playing field. It is a problem that deserves our attention, and I hope those of you in this room this morning will give it some serious thought. Thank you.
Thank you. So, Mr. McBride, another very good segue there. The second to last point that Mr. Baker made was about basically defendants taking matters into their own hands. Don't wait for the judge in the underlying litigation necessarily. Don't wait for the state bar disciplinary authorities. If you see what you perceive to be as fraud on the other side, file a fresh action. He mentioned this case in Texas. The Chevron counterattack in the Ecuador pollution litigation has become sort of exhibit A of this technique. And there, Chevron has employed the potentially very potent civil anti-racketeering law and gone after the plaintiff's lawyers, saying that a massive lawsuit accompanied by explicit public pressure tactics can actually cross the line and become an extortion scheme. To what degree do you think this tactic used by Chevron under RICO in its case may become a model for other corporate defendants? And are there other tools, even other than RICO, to use in this regard?
So I think the short answer is yes, it is going to be a model. It is going to encourage other corporate defendants to do the same under RICO or other statutes. And it's happening already, just in the few months since the Chevron verdict came down in the Southern District of New York. You may have seen that just yesterday, Facebook filed a lawsuit against my former law firm, DLA Piper, and Milberg Cohen, the class action firm, in state court in New York, alleging that those two law firms had represented an individual named Paul Siglia, who had filed a meritless case against Mark Zuckerberg, claiming that he had an 84% share in Facebook. And there's been sort of litigation going on a separate track. This individual, Mr. Siglia, was eventually, I think, indicted. But Facebook yesterday filed a case under state law in New York, not using civil RICO, though they, I suppose, could amend and add that in the future. It's clear that state courts have concurrent jurisdiction over a federal civil RICO case, but they filed it under similar sort of provisions in New York. Another recent suit that Paul, you may have seen, others may have seen, just last month, again in the Southern District of New York, where the Chevron case was litigated. But the large insurance company AIG filed a case not against lawyers behaving badly, but against a former commercial partner that had worked with AIG to help purchase and securitize various insurance policies. And AIG filed a civil RICO case in the Southern District of New York against this former commercial partner of theirs. So yes, I think a lot of companies and their counsel are paying attention to this.
And to add a couple of other examples, the Garlock case, Ms. Brown started out talking about, Garlock has filed charges against the plaintiff's lawyers in that case under RICO. CSX Transportation has done the same. So
right.
I think there's plenty of evidence to support your assertion.
Yeah. It's still, I would say, a maturing area of the law. For those of you who had happily never heard of RICO before 30 minutes ago, it's a law dating to 1970 that Congress passed. It was aimed at organized crime. Of course, in the 1970s, organized crime was really a term of art that was sort of a shorthand for traditional mob or mafia type activity. So it basically said if you are a person who works for an enterprise that's involved in various traditional mob type activity, murder, bribery, extortion, wire fraud, that you could be prosecuted by the government. Congress included a civil provision that we'll get to in a second, but for many years, RICO really was not used very much by the Justice Department, other than in the traditional mafia prosecutions in New York, Chicago, Miami, and so forth. Within 25 years, by the time the mid-1990s came around, I was a young assistant U.S. attorney here in the District of Columbia. It had become pretty commonplace for federal prosecutors in big cities to begin using RICO against drug trafficking organizations, street gangs, and some judges were not totally comfortable with it. Certainly defense lawyers waged a series of sort of losing efforts to say, the Justice Department is using this statute in ways Congress didn't intend. That didn't get very far. Fast forward to today, DOJ is using RICO against non-traditional organized crime enterprises, but in ways that at least DOJ believes comports with Congress's intention. In my own district across the river in Alexandria a couple years ago, we charged a file sharing website called Mega Upload using RICO, and the predicate act there was criminal copyright violation. Congress has added predicates to the RICO statute over the years. But getting back to the civil case, basically, if you look at Title 18, where the most of the federal statutes are housed, the 5,000 statutes that Lisa mentioned, you will find an anomaly in the RICO statute, which is Congress created a civil private right of action for private litigants to use the underlying RICO statute in instances where they can show that some sort of racketeering activity occurred. And it was probably even a more dormant statute for the first decade or two. It really wasn't used at all. Around the mid-1980s, plaintiffs began using it, not really corporate defendants so much, but it was used in some creative, bizarre, even exotic means, typically unsuccessfully. One of my favorites was in Philadelphia. A disco sued the city of Philadelphia, saying that it had been denied a license. And the federal court in the Eastern District of New York of Pennsylvania didn't think very much of that. In the Midwest, a woman going through a divorce sued her divorce attorney, saying that he had induced her to engage in an intimate relationship with her and that he'd violated RICO, that he was sort of an enterprise unto himself and acting very mob-like. The Seventh Circuit did not allow that suit to go forward. But as Paul said, by the early 1990s, companies who had been hammered by tort litigation, primarily in asbestos or sort of the toxic tort area, began using RICO, civil RICO, against not just lawyers and law firms, but against shady doctors, sort of straw patients, victims, and so forth. And that points out an important legal thing that Paul, I think, covers in his book, and that is courts have said that a corporate defendant cannot simply use civil RICO to go after a lawyer behaving badly. And there's a case involving Freshfields, the English Magic Circle law firm, saying that a law firm that simply provides legal services to a class of plaintiffs or so forth, you need more than that. And what you need to prove under the statute as a matter of pleading the civil case is that you have both a person who's then involved in an enterprise. And the courts have said you can't collapse those two. Those are separate elements, if you will. And so you can't simply have an organization of lawyers at a class action firm. Well, I won't name a class action firm, but think of one. And what you need to do if you're going to sue them under civil RICO is do what happened in Chevron, for example, where, as I understand it, Donziger was the person, but then he was involved in this sort of broader conspiracy involving other actors that constituted the enterprise. So that's something that the courts require. But essentially, it is increasing in use. By my own count, I was able to find more recorded cases involving private litigants, companies using civil RICO against lawyers behaving badly, than I could find recorded cases of the Justice Department prosecuting lawyers behaving badly in the same sort of context, right? So I could only find a handful of cases where a lawyer engaged in wire fraud to bring meritless cases against an asbestos manufacturer. I could count, I think on a couple fingers the number of cases I could find where DOJ did that, as opposed to DOJ, policing a mob lawyer who's taking, money from his client or suborning perjury, something like that. But in the classic case of a lawyer using, imposing a fraud on the court to bring meritless cases, very, very few examples of the Justice Department bringing those types of cases. I can say that in my 4 years as U.S. Attorney, I had many occasions to deal with the state bar authorities in Virginia. I should say not, in my personal capacity, but, in sort of the sandbox of the various new rules that they would circulate for comment by various constituencies. I'm not aware of a single time that the Virginia bar ever referred to my office for prosecution an attorney who'd been engaged in some sort of meritless action against a company of the sorts that we've been talking about this morning. Nor am I aware of any of my 92 U.S. Attorney colleagues who ever had similar referrals as well. So, I don't know. That may just be because, as the general said, lawyers and judges are a little bit, there's almost this, gentleman's agreement that I don't want to, touch the third rail by accusing the general of doing something because he's going to turn around and accuse me, and then we'll, there's sort of this conspiracy that we're just not going to talk too much about it. Last thing I would say is that I would commend to your reading, pivoting back to ending with Chevron. What was fascinating about Chevron to me was not just that it was a lawyer behaving badly and supporting perjury and putting together this fraud on the court to bring an action against a company that resulted in an eye-popping settlement, but the fact that it took place outside the United States and the growth of transnational class action litigation is a real interesting development to me. And I would actually commend. It's short, it's about 20 pages, but the Chamber actually wrote a terrific amicus brief in the Chevron case before the Second Circuit. You can read it in 10 minutes and find it online. They may even have copies here. But that brief does a really good job of describing the growth of the class action, the growth of class actions around the world, and particularly in countries where rule of law is not as robust as it is here and in other countries, and how that's just a toxic synergy for the sort of mischief, ultimately fraud, that occurred in Chevron.
Very good, thank you. Let's take a few minutes to address a question I'm going to raise, and then keep a few minutes for questions from the audience, if that's okay. I want to just broaden our focus for a minute in the spirit of comprehensiveness and fairness. We're either explicitly or by implication referring to the plaintiff's bar in terms of our misconduct, with the exception of Mr. McBride's reference to DLA Piper being accused of, in that case, malicious prosecution, but behavior very similar to the kinds of behavior we're talking about here. In the Facebook lawsuit, DLA Piper is accused of knowingly relying on obviously fabricated evidence, lending to an obvious sort of shakedown lawsuit against Mark Zuckerberg. Its institutional credibility, part of the allegations have to do with its, not just its litigation, but its media relations. The Facebook complaint against DLA Piper cites how often the law firm went to the Wall Street Journal, the New York Times, Bloomberg News, and mounted a public campaign. So that's DLA Piper, 4,200 lawyers, very prestigious. The Chevron case, in its many branches, includes, of course, one set of fraud allegations against the late, great Patton Boggs firm, a firm based here, of course, associated with representing big corporations in lobbying and litigation, which, to many people's surprise, ended up on the plaintiff's side against Chevron, but then was implicated by Chevron in the fraud against the company. Ultimately, Chevron lodged fraud claims against Patton Boggs as a law firm in an action that was settled, with Patton Boggs apologizing and paying Chevron $15 million. To what degree are the problems of my question now, to each of you briefly, to what degree are the problems of attorney chicanery, misconduct, also present in our prestigious large law firms that generally represent corporations, but in these two instances, allegedly in the Facebook case with DLA Piper, allegedly, but with a very obsequious settlement in the Patton Boggs case in Chevron, you're seeing the same type of misconduct within the large prestigious law firms. Ms. Brown.
Well, I think Lisa's introduction sort of described what I view as the sort of kaleidoscope of enforcement. And in the corporate context, for a corporate defendant, that is always out there, and that is applied fiercely, frequently, all the time. In addition to that, I think you have the threat of punitive damages over every corporate defendant's head all the time. And for the most part, misbehavior, if you will, on the corporate side tends to be focused on the corporate defendant, not the corporate lawyers. I think what, at least in the asbestos litigation, makes it very different is, and Lisa spoke to this as well, is that it's systemic. It's built into the system. It's created to function the way it functions. And the only gatekeeper to continuing abuse, against continuing abuse on the front lines, are the trial court judges, who, at least as far as we've seen to date, seem to be a little helpless in addressing what they obviously view as a problem, but don't do anything against it. Whereas the corporate defendant, I think, acting in exactly the same way, would be facing sanctions.
Paul, that's a great question, and I was sitting here just trying to think of a nice, cute answer. I'm not sure that I have a nice, cute answer, but let me give you some observations. I think, first of all, in regards to the Chevron case, which you've written so eloquently about, I think most of us who are on the defense side of the practice, we were a little bit surprised at the conduct, at least alleged, against Patton Boggs, a great firm here in the United States. And so that took us a little bit aback because we just didn't think that happened. In my experience as Attorney General, and certainly in private practice, I don't recall any case in which we had this type of misbehavior on the defense side. Now, that's just my personal experience. I'm not saying it doesn't happen. But I think the reason we see less of it on the defense side is because there tends to be a lot more control by the client. As defense lawyers, we are working very closely with general counsels. We're working with the company to engage whatever litigation might be involved. And so there is an opportunity to have some oversight over the lawyers in the case who are representing from the defense side. When you have mass litigation and plaintiffs' lawyers on the other side, that relationship tends to be a bit looser. And I think, quite frankly, in many cases, the plaintiffs are really controlling the litigation and not necessarily with the advice and knowledge, or sometimes even the consent of the plaintiff class. And so I think that creates the opportunity for more mischief on that side. And again, I'm not saying it doesn't happen on the defense side, I'm just not aware of it.
All right. Mr. McBride, any thoughts on that?
So my two panelists just stole my two answers. So
Ah.
the only thing I would add is that, it may be a teachable moment for, big law, for large law firms who typically do defense work and not plaintiff's work or generally or class action work specifically. That, as law firm economics continue to tighten and law firms look for new, uncharted areas, income streams for the firm, and perhaps are getting into things that they didn't do before, they need to be, mindful of all of their clients and do the due diligence before they file the suit. As I understand it, Facebook alleges that DLA knew or should have known that there were red flags in the system about their client who they filed the suit against, and sort of
Right.
Looked the other way.
And they knew, according to the Facebook lawsuit, that a co-counsel of DLA Piper had actually flagged the fraudulent
Right.
evidence and said, hey guys, we're out of this case because we see fraudulent
went forward
evidence,
anyway.
and DLA Piper went forward anyway. All right, well, we've used up almost all of our time, but we have time for one terrific question from the audience. Does anyone want to be that terrific questioner? Yes, ma'am.
I'm Mary Trezino. I'm a consultant to ILR. The Chevron case involved the existence of third-party litigation funding, where an unrelated third party came in and provided cash in exchange, ultimately, for presumably a share of the proceeds from that Ecuadorian lawsuit. To what extent did the existence of a third-party funder contribute to or encourage wrongdoing, and is this something that corporate defendants should be concerned about?
You want to each quickly go for a very concise response?
Well, for good or for ill, mostly for good, to date, I don't think we're seeing it a lot specific to asbestos litigation. The firms that bring a lot of the asbestos litigation do it in other contexts, so I think it just increases the coffers available for use in shenanigans, but we're not really seeing it in the asbestos context to date.
Yeah, third-party litigation funding, especially with regards to hedge funds who are dumping a lot of money in these cases, really does create the opportunity for mischief out there. And it sort of shifts the control of these cases from your traditional lawyer-client relationship and the control of a case to now having a third-party disinterested investor in the lawsuit, which in many cases can shift the outcome and strategies that might be inherent in how the case is handled.
They steal your answers again?
Yes. No. I mean, I'll take a different tack, which is the presence of the third party was actually, in a sense, necessary to plead the case, because, again, you have to plead both a person working with an enterprise. And so to the extent that Chevron said Donziger is the person under the statute, he needed other entities or individuals that he was in cahoots with to constitute the enterprise as a legal matter. And so that was, that was part of the proof.
All right. And I'll leave you with one final thought, just a fact from the Chevron case on the litigation finance front. There were hedge funds, as Mr. Baker said, that invested in this case. There also were individuals. And my favorite financier in this case was a law school colleague of Donziger's named Russell De Leon, a billionaire resident in Gibraltar who made his money in the online poker industry, a true mogul, and he invested some $23 million in the case over time in exchange for a 7% share, not of the legal fees, but off the top of the recovery. So that's an illustration of how the case against Chevron persisted for as long as it did. So, terrific panel. Thank you very much.
Thanks, Mark.